If you find that someone else has registered a domain name containing your trademark, you might think the best or even the only solution is a lawsuit. But litigation can be time-consuming and expensive. Fortunately, in dealing with cyber squatters, there's a popular way to avoid going to court to resolve domain name disputes. Alternative dispute resolution policies, such as the UDRP, are a common and very effective legal tool for trademark owners to obtain control over domain names that are being abused by others. Hi, I'm Doug Isenberg, an attorney and founder of GigaLaw, a law firm that helps clients protect their brands on the internet. In this video, I'm going to talk about the advantages of the UDRP, provide an outline of its important three-part test, and discuss the need to file a strong complaint. Now, the UDRP is the Uniform Domain Name Dispute Resolution Policy. It was created by ICANN, the Internet Corporation for Assigned Names and Numbers, in 1999 as an alternative legal process that allows trademark owners to resolve common issues with cyber squatters and other problematic domain name registrants. Although trademark owners can go to court to resolve their disputes, doing so is often very expensive, very complicated, and usually takes a long time. The UDRP, on the other hand, was created specifically to address these issues. As a result, trademark owners file literally thousands of complaints under the UDRP every year, and Corporate Counsel magazine has even called the UDRP the preferred option for most trademark owners. The UDRP case is typically resolved in only about 2 months. All of the filings take place online, and unlike litigation, UDRP proceedings avoid the hassles and expense of motions, briefs, hearings, discovery, and trials. Plus, the UDRP is incredibly effective, with trademark owners now winning well over 90% of all cases. So, how does UDRP work? The most important thing to know about the UDRP is it includes a three-part test. First, a complainant has to prove that the disputed domain name is identical or confusingly similar to a trademark and service mark in which it has rights. Second, the complainant has to prove that the registrant of the domain name has no rights or legitimate interests in it. And third, the complainant has to prove that the domain name has been registered and is being used in bad faith. Now, of course, all three of these tests have their own legal definitions, and tens of thousands of UDRP decisions through the years have interpreted and applied the language of the UDRP in just about every situation imaginable, creating an incredibly useful body of legal precedent. A trademark owner or complainant must prove in its complaint that it has met all three of these tests to prevail. Then, a domain name registrant or a respondent will have an opportunity to respond to the complaint. And finally, a panelist, similar to an arbitrator in other legal contexts, will review the complaint and the response if there is one, and issue a decision about what should happen with the domain name. Now, on the one hand, a UDRP proceeding is straightforward. But on the other hand, there are a lot of subtleties and complexities in almost every case. Filing a strong complaint involves a lot more than simply filling out a form, because every complaint should contain the strongest possible factual and legal arguments, citing relevant authority, such as previous UDRP decisions, as precedent, and anticipating all possible defenses. Plus, trademark owners should be prepared to respond to important issues that may arise during the course of a UDRP proceeding, because even a very strong complaint is not always enough to win a case. Now, in other videos, I discuss some of these important details about the UDRP, so trademark owners can use this important legal tool effectively to defeat cyber squatters and protect their brands on the internet. To learn more about domain name disputes, I invite you to take a look at other resources on my website at www.giga.law, where you can also subscribe to receive a daily email newsletter about important developments in internet law. Thank you.